If you wish my help and assistance with any of this or anything related to this call, here's where I may be contacted. Some of you may know me from the previous House of Prayer calls that we put on. This is a tradition, by the way. We used to use free conference call, and now we're using Telegram. And so this is a brand new format, brand new location for us. And we took a sabbatical. I took a sabbatical for making calls. Last year, I think we only did 2. And this year, I plan on having more calls. I plan on doing this on a regular basis, with especially since some of the speakers that are going to be on here tonight will probably be asked back again. And I'd be happy to make this House of Prayer Telegram channel benefit for them so that they have a place to share and a place to teach. That's my goal in the House of Prayer. I personally am not a document salesman. I believe a workman is worthy of his hire, what he does. I don't sell documents. Some of you may have remembered myhouseshallbecalled.com. I didn't put that in the slideshow, excuse me, but myhouseshallbecalled.com is a web page, and previous calls are on there and documents galore. So if you feel you can help yourself and know how to create some documentation to do certain things, I've made them available from our many speakers in the past. That thing probably ended in 2020, if I'm not mistaken, with 2 or 3 years of calls on that particular channel. Well, tonight, after the speakers are finished, I'm going to be unmuting everyone. I'd like you to get your pen and papers out, take notes, jot down your questions. If you wish for the House of Prayer to showcase any of these specific topics or speakers, direct message me. It'll be Daniel Joseph in the group, and we can arrange it. Private consultations also are available upon request. Now, for our next speaker, I want to make sure that he's on, or I would like to be. I'm a little bit early. I'm happy about that. The call is a long evening, and if I can be less long-winded, I'd be happy. So let me see if our next speaker is on. Are you there, Ron? Let's see if Ron is on. Can everybody hear me fine? Did I go too fast for everybody? Let's see. Let me find Ron. Okay.
I can hear you.
Good. I'm going to try to find Ron and see where he's at. By the way, those of you, my special guests, if you want to pop in right now while we're waiting Ron to come up there for the dead air space, you're more than welcome to jump in at this moment in time while I'm waiting for my dead air space to be filled with where he went to. Here he is. Ron's on there. Oh, you know what happened? Ron was never added. There you go. Ron, are you there?
I am.
Can you share your screen, Ron? Do you know how to do that?
Let's see.
If you go over to, there you go. Everybody, this is Ron. We've been working together for a little while, and I like Ron. I like a lot of things he has to share. Of course, I like all the guest speakers on here. Ron, I got done a little early. I hope you don't mind. That might give you an extra few minutes if you needed it.
Wasn't sure. I didn't have any kind of formal presentation. I gave a presentation Tuesday evening at 8 o'clock on non-negotiable copyright agreements, security agreements, fee schedules, and the like. In the last several weeks, I've been talking about foreclosure defense, dealing with credit card debt situations, and how to challenge the attorneys in court when they're bringing lawsuits against you in a litigation situation. My background is I'm a certified public accountant. I always tease attorneys when they say they passed the bar exam, and they said it's a 5-hour exam, and then I remind them that a CPA exam is 2.5 days, 8 hours the first day, 8 hours the second day, and 4 hours the third day. And part of that exam is practice and theory, tax, auditing, and law. And, gets into contract law, agency law, bankruptcy, etc. Many things that are covered in a legal arena. But it's more of an arduous exam compared to, I think, the barfly attorney exam. That's just my opinion. But I don't know. Is there anything folks would like to hear about, or I'm pretty well open.
Ron, I didn't make the call is pretty much muted, and as far as the speakers are concerned, your conversation in our presentation previous to this was written about the what did we talk about? I can ask you questions and you can answer. If you want, we can do it that way. We can. I can interview you. I thought we had a presentation that you were going to do tonight, and that's why we had this alleged. I know that we'd asked you to do some of your foreclosure defense information. If you wanted to just jump off with that, some of the things that you've been involved with foreclosures.
Daniel, if I may, real quick, is this the brother that you were speaking with me about?
Yes.
Ah.
Yes.
Perfect. Okay, that's all. Ron, I am glad to meet you, brother, and I'm looking forward to having some conversation with you. I have a very interesting situation that I do believe I may want to employ your services.
Yeah, more than willing to lend a hand and help out my fellow brothers and sisters during this.
Why don't you go through that? Ron, that was the fellow I was telling you about. Folks that may not know that Ron and I have worked together on some situations, and we plan on working together some more in the future. I think he's got a real cool niche, and we've used him and plan on working together. Ron, why don't you talk about that little action that you've put together that this particular group of people may like to contact us about?
Yeah. One of the things I prepare, I'm an expert witness in litigation type engagements involving courts and attorneys and plaintiffs and defendants. And I'm usually retained as an expert to testify on behalf of one of the parties. And I've got several credentials which support my efforts in that arena. One of the things that I've been having some success with is preparing a forensic property and mortgage audit report and presenting that in court situations. And based on my experience in dealing with foreclosure defense and working with homeowners, we found that probably 90% of the time, the real plaintiff, which is hidden, is Fannie Mae. Okay, and there's some question as to whether Fannie Mae is part of the government or not, or an agency of the government. But since 1998, lawyers have been bringing lawsuits attempting to steal homes from the American people under the guise of a plaintiff that's allegedly a debt servicer and not a creditor. And the real hidden party behind the curtain is Fannie Mae. And the lawyers don't reveal that during the litigation. So through our forensic investigation, we found that there is something called a secret lawyer retention agreement, whereby Fannie Mae has retained certain lawyers in the various states around the country, all 50 of them, maybe 5 or 6 law firms within each state, to conduct foreclosures on the American people. Okay? So we've got that through our forensic investigation. We were able to find that lawyer retention agreement, bring it to light, and then along with a listing of all the attorneys by state that are stealing homes across the country on behalf of Fannie Mae. And Fannie Mae is not revealed in the lawsuits. Okay? So that's outright criminal. The other thing we're finding out is that in these foreclosure situations, we find out that there's no debt through our forensic investigation. There's no debt. The debt has to be a ledger account on the books and records of the alleged creditor, sort of an asset on that creditor's balance sheet. It's called a promissory note receivable. And the folks bringing the lawsuit under the plaintiff's name, which is a servicer, does not have that account on their books and records. So there's no debt. There's no debt.
Well, it's interesting, brother. My story is just a bit of a twist on that. I'm one that I was raised as a warrior, and I learned a long time ago, if somebody's hunting you, you turn around and you become the hunter to the hunted. I went after them. I asked them a series of 19 questions, and basically a lot of what you were just laying out, that I have not yet seen the ledger sheet that shows that they incurred any kind of a detriment, basically incurred a debt of whatever nature. And I'm suing them for concealment because they have withheld material facts. And I've done an awful lot of study, a lot of what you're talking about right now. And yeah, in fact, they've been hot potato in this from one third-party debt collector to another, including basically all the way to an attorney service and then back up to the first third-party debt collector. Everybody trying to get rid of it, and even defense counsel has withdrawn as counsel after I've done a few things.
Yeah, absolutely. I mean, I've found the same thing in my forensic analysis and in my expert witness testimony in court cases. It's really sad what's going on in the country here. And, I'm flat out on the side of the American people, and I'm doing whatever I can to stop it and keep people in their homes. See, most of the attorneys, they come prancing into the courtroom and they're waving a promissory note and a mortgage agreement or a deed of trust. And they're saying, well, we've got the note and we've got the mortgage agreement, so therefore we have the debt. Those two documents are not the debt. They're evidence of a debt, but they're not the debt. The debt is the general ledger account in the books and records of the creditor, the true creditor. And they don't have that. And, in your litigation, you've got to go after them to produce those documents in a discovery process.
Yeah, it seems to me that the biggest part of those documents, and I'm just going to the most logical sense, because like you said, without the ledger sheets, everything else is basically worthless. To me, it's just proof that ink sticks to paper. That's it.
Yeah, I mean, for those who aren't familiar with accounting and general ledgers and journal entries and books and records, think of the ledger account as your checkbook, in your own personal checking account. That's the ledger. And the creditor has to have that on their books and records. And if they don't, there's no debt. Absolutely no debt. And, part of the job of the expert is to educate the judge or the magistrate who's presiding over the case, because 9 times out of 10, they don't really know all the debits and credits involved in bookkeeping and financial statement preparation and keeping good records in terms of financial statements.
And that's exactly why I want to hire you services, brother. If it goes to trial, yeah, I'm bringing you in, bro. I'll pay everything. I'll roll out.
I haven't lost the case yet.
I'll tell you something, Pops. What's really interesting is we've been talking about there's a number of ways to use the forensic report that Ron has put together. You don't have to wait until you get to trial. As a matter of fact, just putting this out there for the listening audience, the attorneys would be bringing fraud upon the court if they are getting foreknowledge of this and then continue upon the case. Their butt is on the line. They're in deep doo-doo if they're made aware of these things. So it's literally a great move prior to litigation, because litigation is costly. I mean, nobody really wins in litigation, even if you win, because you spent your time and your money, your energy, and your frustration. So So
I agree, and that makes sense. And I may very well do that. I may take your advice on that.
No, I'm not trying to sell Ron, but when you see the facts that he lays them out in the forensic report, that's the exact reason why we can use it in a declaratory action. We can use it in our debt validation process. We can use it in communication with any of the trustees in a bankruptcy. There's a multitude of uses that this tool that Ron's put together can be used. So go ahead, Ron. I'm sorry. I didn't mean to cut into your 25 minutes.
Yeah, I'll mute out again. I just find it all interesting, and just
it's exciting.
It fits so well what you're doing.
We talked about Ron. If you wouldn't mind, you can probably also put in the other tool that we both not, because this is not my time. But if you need some more space, you can talk to people about the possessory lien and how that also works in tandem as a tool with your forensic examination. I'll shut up and let you talk. Sorry.
Yeah, I mean, the other tool we develop and put together is called an affidavit of secured interest and non-abandonment. Okay, and as the homeowner, we've made many improvements to the home over the course of the time that we've owned the home and had possession of it. You know, we did some landscaping. We might have painted the house a couple of times, put on a new roof. A month ago, I had to put in a new furnace in my house, and 3 years ago, I had to put in some air conditioning chip compressors and airflow equipment. You know, those are expensive items. So what you do is you put together a laundry list of all the improvements you've made in the house, along with all the real estate taxes you've paid, all the homeowners insurance you've paid over the years, and all of the capital appreciation you have in the house. Let's say you bought a house for $150,000, market value has gone up. Let's say it's now worth $400,000. So that $250,000 in capital appreciation that's due you, and that's your equity. So what you do is you put together an affidavit of all these expenses, get it notarized, and then file it with your county registry of deeds. In Massachusetts, each county has a registry of deeds, and you can actually file it into that record as your investment in your equity in your house. And for example, it could be $300,000 or $400,000 in improvements you've made to the house since you owned it. Well, that's your equity. So you should file that and put a lien on the property as belonging to you, similar to when a bank puts a mortgage or a deed of trust into the registry of deeds or the county courthouse, noticing the public that they have that claim on the property, the amount of the mortgage. Well, you can do the same thing for your own investments. Because, if you look at your mortgage agreement, if you bought the house with your wife or you bought it individually, it says tenant in common, joint tenancy. Well, what's a tenant? A tenant is someone who's occupying a home and paying a monthly rent to the Lord, right? The landlord. So when you're a tenant, you're really not the legal owner of the property, but you have the possessory interest in the property. Okay. So you want to put those expenditures that you've made as a claim against the property, against the title of the property in the registry of deeds. And that secures your place and your grip on that home, so that if you ever declare bankruptcy, you're going to be paid first out of the bankruptcy proceeds, because you'll have the highest lien on the property. The bank might be second, and there may be some unsecured creditors waiting in the wings in the background. But it's a way to make your title bulletproof and rock solid. Those are just some ideas that strategies we've developed and we've implemented here successfully. Any other questions about that?
Now, actually, there's a comment. Derek he didn't see my invitation to the call, I guess, but he did put some comments in the chat I'd like to put on the call in case people don't get the chat. He wrote, there never was a loan. He wrote, the bank refuses to produce IRS Form 1098 and IRS Form 1065. And he said, look at Title 15, 1635, in which I agree with the rescission, that beautiful section right there that you've got 3 years to use according to that Title 15, 1635 as I've read it. That's the rescission. They did not give you the right to rescind, and then of course when they don't, it extends to when they first do it, when they first give you their. Have you seen that, Ron? I think I shared that with you on the client.
Yeah, I mentioned that earlier a couple of weeks back, and you folks are the ones that created the credit with your signature on a document to create the funds to make those purchases. The bank merely took those documents, went to the U.S. Treasury, got credits in return, and then they kind of hoodwinked you to sign some more papers called a promissory note and a mortgage agreement when the money was already made available to the bank. You know, when you filled out your credit application and submitted it, and the bank called you up, a week later and said, hey, your credit's been approved. What they're really saying is, we've already got the credit, the money, the debits and credits from the U.S. Treasury. The money's available, but we want you to come in and do a closing process and sign a promissory note and a mortgage agreement where you turn the property over to the bank. They want to get paid twice. You already paid for it when you filled out the original credit application and put your signature on that application.
Well, Ron, wouldn't it be true that
twice? Wouldn't it be not twice, but 4 times?
Well, I was actually going to say
I was being kind.
Well, yeah, kind of, because it seems to me that there's, especially in the essence of a mortgage, there's the original application, which they convert into promissory note in itself. Then to start the escrow process, they have you sign another promissory note. Then during the escrow process, they have you sign 3 more promissory notes. That's 5 times the amount. And then if you pay that loan off with the interest, it equates to typically about 3 more times the amount of that mortgage, which makes it about 8 times the amount of the mortgage.
Voila. That's what you call Babylonian money magic.
Right.
And by the way, I seen Treasury transcripts through an attorney that actually proves this point. I seen it with my own 2 eyes. 4 times. It was 4 times, not 5. But the 5th would have been the client paying off the mortgage. Now, Gene Keating had proven many years ago that the deal was done at closing. It was done at closing, and like you just said, Ronald, the signature took care of everything. He had ordered a file on the case. He didn't tell them what they wanted. They sent everything. And they had a special HUD for the bank. The client never saw that HUD. That particular HUD statement showed that the entire transaction was canceled out, zeroed out, there was no debt. But the mortgage or the deed of trust is what traps people off. The note took care of the property. It took care of everything with regards to the seller. It was the deed of trust and mortgage that traps people off. And he proved that with documentation and won that case. So you're correct, Ronald. It's done in the beginning based on what Pops brings up about the application, because that's the first step. And we have shown proof of monetization of the application itself with QFIT numbers attached. I've been involved in the law 36 years and been dealing with foreclosures about 15. I recently got out of it. And the secure equity interest thing that you just described is something that I've done years ago. It works. And what I use it with is to use that asset to offset whatever they perceive to be owed, due and owing. it cancels it out. Because if you have a mortgage over 3 years, you wiped out the debt based on your maintenance of the property itself. And that's how we get rid of it. Also, when I get to speak on what I do, once you get the status correction of the record corrected, this thing can be taken care of with one piece of paper to Treasury or the Social Security Administration. No fighting. We're doing too much fighting. I yield because I don't want to take up your time.
That's okay. And folks, Private Nobody will be on our speaking agenda after midnight, so get your coffee. Ron, Derek's on the call, and he had a couple things. Derek, I unmuted him. If you wish to engage with Ron, you definitely have the experience with some of the subject matter. We've been through your classes. I open, and I will yield you to go ahead and banter back and forth. We got about another 17 minutes before the next speakers are coming on.
Yeah, go ahead. Fire away.
Well, I did unmute him, but he didn't jump in.
Okay. Anybody else there waiting in the wings? Let me just say this. When you fill out that credit application for that home purchase, if you think about it, the information you put on that credit application is the name of the bank, right? The amount that you wish to borrow, or the credit you would like to engage in, the date, you date it, and you put your signature on it. Now, how is that any different than when you're writing a check to pay a bill or whatever? It's no different.
Pretty much the same.
Both documents are negotiable instruments under Uniform Commercial Code, Article 3, Section 104. If you look that up under the Cornell Law School website, UCC, Article 3, Section 104, you'll see negotiable instruments. And a promissory note and a credit application and a banker acceptance is a negotiable instrument. In effect, it's money.
The problem with the
your
UCC
signature on that document, you created the money.
The problem with the UCC, Ron, is when you go to
black man and woman created the money.
the problem with the UCC, Ron, is when you go to use it in court, they're going to tell you, the judge is going to tell you that it's not the law and that it's not applicable in this circumstance. And he's correct. And I had to learn this the hard way. It isn't the law. It's a mere suggestion. It resembles
It's
the
the
law.
law of the merchant. It's how commerce is operated and run.
No. The
Yeah,
rules.
the UCC came in after the Bretton Woods conference after World War II.
You have to go back to the foundation. It's not the law. They're a set of rules. Okay, and those rules, there are times they apply, and then again, there are times they don't apply. And unfortunately, for most of the commoners who don't know how to enforce rules, they will never apply in a court. So let me give you a secret on how to expedite your path. It's 40 statute at large 411, 48, statute at large 112. Title 1 USC 112 tells you that the statutes at large are legal evidence of the law from the highest court to the lowest court. They mention nothing about the UCC. Okay? And the next thing is the Bill of Exchange Act of 1882. As amended, it was amended in 1882. Originally, it was derived in India for international commerce. Okay? This is where the UCC is derived from, is from the Bill of Exchange Act. Now, the Bill of Exchange Act is, in fact, the law of negotiable instruments. And the lawyers crafted the UCC because it's a crafty way for them to steal your equity. You are a preferred stockholder in the United States after 1933. And so when we use the actual law, it doesn't grant rise for the judge to be able to formulate an opinion based upon what the legislator's intent was. Now we're using 48 statute at large 112, 40 statute at large 411, Title 12 USC 411, 412, and 413. And because of that, they can't overcome it. There's no law that requires you to enter into a mortgage. And Congress tells you in Title 15, USC 1601 through 1693, that the only way that a debt can exist is by agreement. So your over-the-counter security becomes an asset on the ledger, which is their bank liability, and you're due and owing that amount. They never gave it to you, so they never gave you a loan. But what does the mortgage deed of trust say? Mortgage deed of trust, the documents within the mortgage deed of trust says that you agree that you received a loan. You never got a loan. And to prove it is under Title 12 USC 411, 412, and 413. They're supposed to redeem it in lawful money dollar for dollar. That's 48, statute at large 112, which says that our notes are a foreign currency. Notes, drafts, bills of exchange, bankers' acceptance, trade acceptances are a foreign currency that are supposed to be exchanged dollar for dollar. That's Congress's guarantee to we, the American people, so they can float their form of government. They utilized our assets. They mortgaged everything. It wasn't the fact they took the gold and silver. It's the fact that they mortgaged everything. And another word for mortgage is trust. So that's why once you can prove that material facts were not disclosed, Title 15, USC 1635 becomes your best friend. Because Title 15, although not enacted into positive law, I'm not saying that it is law. It's equitable in its nature. It's equitable. It's your equitable right of redemption. Congress gave you your perfect affirmative defense. It's not an argument. It's a fact. And so that's why I urge people to go read the 73rd Congress First Session, Volume 77, Part 1. It's like 1,165 pages, and it's well worth your time. And it tells you what the new money is. And it tells you that the new money is notes, drafts, bills of exchange, bankers' acceptance, trade acceptances, launched to a credit application with a warehouse receipt. So what the bank is doing, the bank is acting like a pawnbroker, and they're taking your receipt from the transaction, and they're going back to the Federal Reserve and getting an extension of credit based upon your credit worthiness. And they're using you to pledge your asset to secure the loan. See, you can't pledge the house if you don't own it. But what's the first thing they have you do on a house before you can sign all the mortgage documents? You have to sign an affidavit of ownership of the property, and they record it. So once you can see the big picture, it's really easy to defeat it without a bunch of arguing and quibbling in a courtroom. It's real simple. Demand that they pay you the payable side of the ledger, because your over-the-counter security is an asset, which is a liability to the bank, and that's what's due and owing to you. Point blank and simple. But anyway, I'll yield. I just wanted to help you guys out, because it's really gotten simple for me in the most recent years. Just understanding that utilizing Congress for what we put them in place for, to protect our unalienable rights and to protect our assets, has become really easy in just a few short strokes of a pen.
I can say this real quick. After I decided to squeeze the trigger on the mortgage companies, I then buried my head into learning all of everything that Derek just talked about, and he articulated it far better. He's got it far more memorized than I do, and I applaud the brother. But everything he said is, yeah, it's hitting the nail right on the head. Correct.
So the simple answer when you come under attack, that would be that the defendant never received a loan, that the mortgage is not in arrears. If you look in the mortgage documents, all arrearages can be caught up at the time of maturity. So nothing's due and owing until maturity. Of course, that's when you've gotten your percentage rates and you cash out the layaway plan, and you have more money than that. So the defendant never received a loan. The mortgage is not in arrears. Plaintiff's presentments are forgeries, and plaintiff has never produced the money net daily transaction report, log 120, which is a Federal Reserve report that shows the source of the funds and the destination of the funds from that letter of credit, application of credit. That's a Article 5 letter of credit, which would show my name as the source of the funds. So the plaintiff has not produced the money net daily transaction report, log 120. Plaintiff has not produced the Form 1098 or 1065 or the 1160. 1160 makes the property's foreclosure property. It's with Fannie Mae. It's the Form 1160. And the third one, what's the last one, Derek? I've never received a loan.
Federal Reserve Form 2046.
Yeah, the Federal Reserve Form. How they went to the Fed how they went to the Fed window.
Every state has Rule 12 out of Texas. Go look up Rule 12 out of Texas. It's attorney of no authority. Every attorney is required by law to produce their delegation of authority, warrant of attorney when challenged. Otherwise, if you don't mention it, you waive it. Don't ever waive a fucking thing. And I like them to come after me first versus me going after them, because if I'm the plaintiff, I have to prove everything. If they're the plaintiff, I get to pass the onus of probandi onto them, and they're fucked.
So instead of for the basic answer, we deny everything. That's in a judicial state. In a non-judicial state, you would want to do a quiet title action alleging these same elements, and have the other side come in and demonstrate those elements, and to get a quiet title on the non-judicial foreclosure state.
And that's where
let me
foreclosure state, and basically I asked them a lot of questions, 19 to be specific, that would have been all material facts to disclose whether or not they actually incurred a detriment, the whole 9 yards. And what I'm suing them for is concealment. I did an administrative process. I got every stitch of it documented, and I can prove what I had attempted to do. And I have proof that they never once have ever responded back, ever.
But with the positive statements I made, I would say defendant never received a loan, and you do a negative affirmative. I've seen no facts or evidence. Defendant never received a loan, and now that affidavit they would have to come back and rebut the affidavit and arrive at a declaratory judgment.
Now we can make this very quick. If you can get a hold to an attorney, is to go to Treasury and have him to order the transcripts under that account. And just like somebody mentioned before, and I seen this, the all cap name will be shown as the creditor. Game over right there.
Daily transaction report.
Yeah,
you can also do it.
And number two, the proper terminology that they use with regards to you didn't receive a loan is that the loan was never consummated. The loan was never consummated. And you can look that up, and it goes to, it will show you that if they cannot prove the consummation of the loan, they're done. So between the Treasury transcript and the failure for them to consummate the loan and prove it, ball game over.
If you look up money,
Form 430 as well.
Which one?
AO 430.
AO 430 for the administrative office. But you realize the consummation of the loan, we loaned them the credit application. So we loaned them, so there was a loan. The defendant never received a loan. And
that's what the Treasury transcripts will show.
That's called the MoneyNet Day. If you type in MoneyNet Daily Transaction Report Log 120, you'll find Enron's MoneyNet Daily Report from that whole Enron scandal, and it shows who the source of the funds were.
The destination of the funds, most importantly, and then that shows that the accounts payable belong to you, and you haven't received them yet. See, what the bank does is they just create numbers on their side of the ledger. There's no money that's created. It's about ledgering, guys. You have to understand there was no medium of exchange except for the fact that you gave them an over-the-counter security without instructions, and you can allonge instructions to it at any time. You're the accredited investor.
So Derek, part of the trick is we had them at I go to 7-Eleven, I buy a Slurpee for $1.50. I hand them the $1.50, they give me a receipt, and I walk out. So we put together an application, a signature in blank, without a memo line, without a pay-to line, without instructions. We hand them the application, don't get a receipt. Then they go ahead, fund the escrow account. Then we come in at closing to do this promissory note. And then we hand them the promissory note and don't get a receipt. If I go to Walmart and I buy some good out with cash and I throw the receipt away, the little Walmart cop at the end of the hall is going to check my receipt or tell me to go buy it again or beat me up if I try to walk out. The receipt shows I paid for something. We don't get a receipt for the application. We don't get a receipt for the promissory note. We don't have any proof that we paid for anything. And we should be able to get the mortgage back. I was a mortgage signing agent in Florida with a big bond as a notary, and you can get the closing package at least 3 days, if not 10 days before closing. You can demand it, and then you could go record all these things. You could record the note beforehand, and then you, of course, get a receipt or make your own receipt. And you could also do a UCC 11 search to see if there's any liens. If there's no lien on the property, well, they don't have a standing to foreclose also.
There is.
You realize every.
Go ahead.
But you realize this application process is the same application process for electricity, internet, and it's an application for a driver's license. They're all letters of credit applications. It's the same game on the back end, and to some degree in fashion, but it's the same game. We're funding them with a letter of credit.
When you read 31 CFR 357, I just happen to remember it because 357 is a good round to send down range. 357 clearly tells you that the Treasury is never in default. They always honor our applications. That's why in Title 15, 1691, you can never be denied an extension of your credit because that would be breach of Congress's duty to ensure that you have everything that you need out of necessity. Now, whether you need a $1.3 million house or not is none of the concern of Congress. They just have a fucking duty to perform, period.
Well, what typically happens,
they always perform, and then they say that they're released from any liability and indemnified because they always perform, therefore they're never in breach of contract. And as such, the Treasury turns around and says that you, the applicant, bear all the responsibility to make sure the transaction goes through smoothly. So it's your duty to respond to
our duty,
you're dealing with, to inform the Federal Reserve Bank, who keeps a funds account, which are notations of your Treasury book entry securities, and to debit the federal account and credit the one that you're using, which is your securities account, to make sure that everybody's made whole. And it's never done. So what the banks are doing is they're using their own system to data log bookkeeping entries, ones and zeros on a computer screen, but you're never authorizing the transfer of funds from the Federal Reserve to the proper bank to make sure you have the funds available to you.
So what typically happens with a normal mortgage, you go there, you go there, sign the promissory note. It's the first thing. Don't get a receipt. Then you sign all those mortgage documents. And what they do is they take that promissory note as a promise. The first thing they do, they stamp it, pay to the order of Bank of America N.A. without recourse, signed by the vice president. And that third-party endorsement might happen 3 times. Bank of America N.A. to Mellon Bank, and the final endorsement on that note would be paid to the order of no name. It's negotiated, so it's no longer a promise to pay, it's an order to pay. So they destroyed the note, altered from its original purpose. And so this note holder is sitting on this money that's been negotiated, it's order to pay, and they go to a third bank like Westar Bank in Las Vegas, and they say, hey, I have this note here for $500,000. I would like to pledge this note for a loan from you, and it's called a conduit loan. And so the bank says, sure, we'll do that. And the $500,000 comes from the Nevada bank that pays the seller. And then they arrange this retail installment again on a buy-sell agreement, retail installment agreement, where the person who wrote the note becomes an undisclosed third-party investor and an undisclosed beneficiary to an irrevocable trust in the servicing company. And we bargained for I got a 1% mortgage. Oh, that's great. So you're going to make 1% over 30 years, as opposed to 29% over 30 years. You would have made a lot more money over that 30-year period. So at the end, if anyone has finished their mortgage, or even if you haven't, that accumulation of both sides of the ledger that was with that servicing company, that's still your credit. Most people don't go demand that the cash out from that as beneficiaries, an undisclosed beneficiary to that irrevocable trust. And that goes into the withholding thing with the W-4 that I like to do. But that's typically what happens. It's a conduit loan, retail installment agreement, a buy-sell agreement, where we become undisclosed third-party investors and beneficiaries to an irrevocable trust. And if you get the note back, if you can get a certified copy of that note back, like if you go to bankruptcy and they have to go and the creditor has to produce a certified copy of that note can go be cashed in because it says pay to the order of nobody's name. Put your name in there. It'd be like me giving a check to Derek and Derek endorsing it over to Ron and Ron endorsing it back over to me. It just goes round robin and you can go cash that note back into the bank.
Ladies and gentlemen, we don't expect to get a whole seminar on this subject matter in 25-minute section, but Ron.
Oh, okay, sorry about that.
No, you're doing good, man. You're doing really good. I got Boris and Kevin on there that just bounced from another call. They're a couple minutes late. Ron, it looks like you were taking some note down there. I think some of that stuff can be added to your forensic examination. What do you think?
He said a lot. I didn't quite get it all.
There's a recording
of what Smoking Baby said there.
You got it, Ron. There's going to be a transcript. Thank you very much. And Smoking Baby's on tonight as well, and he's got his own little section.
Hey,
right now,
Baby, send me an email or something. We ought to talk.
Okay, I'll get it. We'll get it to you somehow.
You have my number or my email?
he's got an attachment right here to you, Ron. He can literally send you a text over on Telegram. Just watch for it.
Where is Smoking Baby out of?
Arizona. Well, I'm in Arizona right now.
Are you in the finance area, or what's your career?
I love the IRS. I love taxes. I love the IRS.
You guys will get a chance to talk. We got to move on, guys. Thank you, Ron. I really appreciate it. Thank everybody. Everybody give Ron a thank you. There you go. I'm going to go ahead. Appreciate you doing this very lively call. I got Kevin and Boris on here. Ron, if you wouldn't mind, just go ahead and cancel your screen there, so these guys can share their screen if they want to. If you know how to do that.
Thanks, Ron, for talk. That's good info there.
Yeah, really good discussion there. Let me just get off here. Is that better?
Kevin, do you